All right, folks, it's time for our favorite podcast. We're doing a little extra special version today. Live with me here is Christos Lagos in the Concord building, downtown Miami. How are you doing today, Christos?
Good, Greg. How are you?
Excellent. Christos is an up-and-coming attorney in Miami. He's handled a lot of complicated cases, including the bridge collapse. And so I know a lot of people have been asking questions about infrastructure, what's going on, are my bridges going to get fixed? You know, why are we fixing bridges? I opened the paper today and I saw Surfside, the Surfside building collapse settled for almost $1 billion. So
That's right.
That's also an infrastructure building that collapsed. I mean, who would have thought about it? Right behind us, that's the Miami Dade Courthouse. So when you deal with guys like us on the other side, you got to realize that we are literally right across the street from the courthouse. How exciting is that? But that building as well has a lot of problems. So you might hear in this podcast today sounds of construction, and that's what's going on. We're building a new courthouse right next door, and to replace this courthouse because it really can't be fixed. So what we're going to talk about today is the FIU bridge collapse, which this gentleman here was like the top of the food chain in terms of all the lawyers representing all the individuals that were harmed by that bridge collapse. All these powerhouse names: Stuart Grossman, Alan Goldfarb. Don't confuse the last name with my last name. He's not my father, although he does have a son with my name. Sam Pedro, Gary Fox, Joel Ryan, John Romano, many other very, very good lawyers. And they all selected this gentleman over here to basically be lead counsel, to be the one in charge of all things. So that was a major honor for you, and you did a fabulous job.
I appreciate that.
All right, so, you know, one of the other portions of this discussion, because I'm getting questions in a lot of my Mass Tort podcasts about bankruptcy. Can all these multi-billion dollar corporations get off the hook by filing bankruptcy? So in the FIU case, interestingly, although it wasn't a multi-district litigation mass tort, it was sort of handled like a mass tort, and they also were involved in bankruptcy. So Christos can dispel a lot of the concerns that I know a lot of people that are involved in mass tort litigation, either as plaintiffs or as attorneys. He can tell you what happened in the FIU case, and he will. Okay, so why don't we start from the top, Christos, and just let's talk about the bridge. When did it collapse? How did it collapse? What happened with that?
Sure. I wanted to first say it's a privilege to be on your program, and I've listened to many of your podcasts, video podcasts, and you do a great job cutting to the chase. So I'm very privileged and honored to be on this program.
Thank you. Thank you.
Now, and I've admired you from a distance, but you represent hundreds of people harmed by defective products, and it's also a privilege getting to know you better.
Yes.
That said, let's talk about the FIU Bridge case. So for those that don't live in South Florida, or maybe didn't learn that much about it through the media, what happened was on March 15th, 2018, a bridge that was still under construction over an open roadway collapsed, crushing people underneath. Killing 6 and injuring dozens more. 20 plaintiffs filed suit across the street and against eventually 28 defendants. The first wrongful death case was filed by me, and it involved a man that was under the bridge. He was a truck driver. It was during his lunch. He was in his personal vehicle, and he was stopped at a light, and the contractors were doing some repair work over an open roadway days after this bridge was moved into position, causing it to collapse and killing my client. So what happened was the night before I filed my complaint, which is a couple of days after the collapse, after his death, the NTSB released a statement saying that they were aware that the contractors were tensioning these tension rods, and tension rods exist to go through concrete, and they tension them with this high tensioning process to compress concrete to make it stronger. And by doing that, it's very dangerous. You know, any construction or any work over an open roadway is forbidden. Not only using common law negligence or common sense, but also FDOT standards, right? You can't do work over an open roadway. You should close the road down. Why they didn't, who knows? But the bottom line is, many people were needlessly harmed and killed, and families were destroyed in this case. So
the bridge just fell to the ground.
It did. It fell to the ground. Yeah. And what's more troubling, though, is that this unique bridge, which was a 950-ton concrete bridge, was built on the side of the road first under a concept called accelerated bridge construction. It's called ABC construction. It's built on the side of the road, and then it's moved into position with these very heavy lifting trucks. So in this case, they knew a couple days before they moved this bridge that there were cracks. There was cracking, and the engineers, the lead engineers, even called FDOT, left a message to FDOT saying, "We noticed there's cracks, but it's of no concern." They moved the bridge into position, and a couple days later, on March 15th in the morning, the day of the collapse was in the afternoon. They had a safety meeting, and the lead engineer had a presentation saying, "There are cracks. We don't know why there are cracks, but it shouldn't be any concern, no safety concern." Unfortunately, he was wrong. And the subcontractors went up there, they were tensioning, and actually workers were also harmed, but the public, the notion that this could have been prevented if it just stayed on the side of the road is just so troubling that they decided to move it into the public right of way.
Yeah.
So at the time that the bridge collapsed, there were workers actually working, repairing the bridge, tensioning these tensioning rods, which is a very dangerous thing to do. And they should not have put people in the way of needless harm, and they did. Yeah.
So they didn't close the road off while they were doing this work?
Unfortunately not, no.
All right. And was it a new bridge? Was it replacing an old bridge? What was the situation there?
So it was a new bridge, and it was a bridge to solve the problem with in Sweetwater. It was a bridge that would connect the campus over Tamiami Trail. And if you're not from this area, Tamiami Trail is a very big roadway. Many lanes. And so it's a pedestrian bridge to make it safer for students to cross to get onto campus.
All right. Wow. So that was the bridge that collapsed. Was the bridge that the students were going to walk over for safety purposes, right? Wow. That's crazy. All right. So all right. So there were 20 different plaintiffs that actually filed. So they hired their own lawyers, they filed suit. So how did you become lead counsel? Like why didn't everybody just have their own case going on at the same time?
Yeah, no, that's a great question. And it's actually, there are parallels to what you do in the MDL world, obviously, multi-district litigation. So it would be very difficult logistically to have 12, 15, 20 cases going on in front of different judges. And so I filed my case. It went in front of one judge. Several others followed suit, and they were in front of other different judges. And so what one of our administrative judges, and I give her a lot of credit for actually resolving this so quickly, this case, Jennifer Bailey, decided she's going to consolidate the matter, and we would consolidate it for the purposes of discovery, for the purposes of pretrial motions. And, you know, this is because of the number of plaintiffs, it's not suitable for class action, and also because of the different damages, they would have to be bifurcated for damages anyway. And multi-district litigation involves different districts. It's the same jurisdiction, right? Miami Dade County. So she consolidated and said, and we had a couple of hearings, but what she wanted was to run it. And she's done, she's got her master's LLM at Duke. And I also, she recommended me to go and get that MDL certificate from Duke Institute. And so she has the experience of managing cases like this, or cases that are quasi-MDL. So what she suggested was that the plaintiffs select the liaison counsel and the defendants select the liaison counsel. And that typically happens even if the judge doesn't say that, because you want, when there are 20 different plaintiffs, you know, some judges I've heard, and even lawyers on the defense side, say that plaintiffs' lawyers don't run well together. I disagree. I mean, we're stronger together.
Yeah.
And there's no one person that handles a big case. You know, it always takes a team. If you see lead counsel or liaison counsel in a big multi-district litigation, there's an army of people that are supporting that person. And so, but the judge wanted liaison counsel for each side. And then the judge said, I want one liaison counsel to interface with the court. And so essentially it happened at one special set hearing where MCM's counsel, Andy Crook, who was a very exceptional lawyer, I was standing there at the podium on the defense side. I was standing at the podium on the plaintiff side. And when she said she wanted one liaison counsel, I immediately said, I'll do it. And so in state court, you don't have these very experienced clerks like they do in federal court, where they draft the orders for the proposed orders. And so the judge had to do a lot of work. I mean, she worked as hard as we did. But I wanted to be the one that initially drafted the orders so that the defense works off of my version.
Yeah.
Instead of the other way around. I wanted to be the one that the court can count on, to basically coordinate everything from the hearings, that any kind of issues, like we had a couple hundred lawyers on a conference call, on a conference line, and then typically 100 lawyers in the courtroom with media, and so I would coordinate the binders the judge wanted. I would consolidate everybody's motions. My team did, my firm did, right? And of course, I say it takes a team. My partner, John Priovalos, he was a former prosecutor, so was I. And so another interesting aspect about this case is how, using or working with federal investigators. And a lot of agencies investigate, wrongdoing by companies. In this case, the NTSB investigated immediately, had this emergency response team that came on the scene and preserved all this evidence. And so, knowing how to interface with these, federal investigators, John and I went up to Washington and met with NTSB's counsel. And even though we were not technically a party to the investigation, only the engineers and the contractors were, we still had the right to talk to the general counsel. And so one thing that we did that's unusual in this case, but has been done before, is to secure a protective order so that we can, through the litigation process with a protective order only through the parties, right? So we couldn't disclose to the media or other third parties. We can start exchanging information, getting information from the engineers and defendants, because for a brief period of time, the defendants kind of used it as a shield. They said, well, the NTSB has barred us from sharing any information. So judge, there's no discovery. So that takes me to something with respect to the public perception of cases when something's in the media or has media attention. The public wants to know what happened, and so the NTSB has these press conferences and they explain things at times. But I think it's important that, for the public to trust the process and trust the judicial system, that the lawyers involved in the case know what's going on and they're moving the cases forward. And we were able, with that protective order, to get enough information to then eventually resolve the case.
All right, so let's take a couple of steps back, just so the audience knows. What does NTSB stand for?
The National Traffic Safety Board.
All right,
so transportation safety.
Transportation, yeah. So oftentimes when you have homicides involved and the agencies get involved, it becomes, their domain, and they're not going to share any of that information with private litigants.
That's right.
And so when we talk about discovery, it's the search for truth, to get all the information, what happened. And a lot of times as plaintiffs lawyers, it's very difficult. People just, the normal tendencies, if you did something wrong, cover it up. Don't let the other people find out what's going on. But it's our job as the plaintiffs lawyers to get that information. And oftentimes when you have agencies involved, it becomes almost impossible to get that information. So the truth, or the agencies in bed with some of the industries, there's always rumors that that's going on or whatever. But in your case, you flew out there and you met with them and you made sure that, your clients and the other plaintiffs got that information.
That's right. That's right. And I also met with Kathy Rundle, my former essentially boss, who's an exceptional person as well. I got great training there 23 years ago as a prosecutor. And I worked with the investigators here on the ground, boots on the ground, the Miami-Dade police, the ones that were lead investigators. They were looking into potential culpable negligence. You couldn't rule out the fact that there might have been some crime that occurred.
Yeah.
There have been no charges filed to date. I don't know if there will be, and those are difficult cases to file because, of course, there was no criminal intentional wrongdoing, right? Yeah. And that's where we come in, right? And sometimes, corporations will make decisions, for example, profits over safety, or cut corners, maybe to speed up a project so they don't get fined or for whatever reason. Yeah. And that's where we come in. We fill in that gap because, first and foremost, if somebody's prosecuted, the only sanctions that we could seek are jail or something along those lines, probation. But in our system of justice, in the civil justice system, we can compensate our victims for their loss and sometimes punish people for wrongdoing that's just negligence and not intentional criminal wrongdoing. So we worked with the state attorney's office. We worked with the investigators here with boots on the ground. Of course, we worked with the NTSB as well.
All right. So one of the things that I read and, just kind of did a quick read through the settlement on Surfside. It was an enormously large settlement. I think it exceeded what most people expected. But one of the fathers of the victims who died, from what I gleaned in the article, investigations have not been completed. And it doesn't sound like there's really, at least from a lot of people's perspective, had a definitive understanding of what happened. So one of the fathers said, all the money in the world is not going to replace my daughter. I want to know what happened. Like just knowing the full truth of what happened to cause that collapse was so compelling to this individual that, he's sort of left, not feeling like he's being made whole because the investigations are still ongoing. Maybe they don't conclude. I think the local investigation, whether it concludes or not, is, dependent upon whether they have the money to conclude that. In your case, in your bridge case, do you feel like like that resolution, that part of the resolution has completed?
It has.
And so tell me about it. Like what caused the bridge to collapse?
Two things. Well, what caused the bridge collapse? Well, in any engineering disaster, there's usually more than one reason. The reason I know, instead of giving my opinion, I'm going to give the NTSB's opinion, which is, again, a remarkable agency that investigates. What they do is they find they find in their opinion why a disaster occurred, and then they make recommendations for the future so that these things can be avoided, which is a wonderful thing, So that's their role. So what they concluded was a couple of things. First, the bridge was not designed properly.
All right.
So the things that were the trusses, some of the arms of the bridge were not designed properly with redundant design, and so if one member of the bridge piece fails, the whole bridge sort of collapses. So there was in plain English, there was a defect in the design of the bridge. Now, what engineers are required to do with engineering drawings, especially of this type, is to have a peer review engineer check your work, check your math. And so they hired another company, Lewis Berger, that checked their work and said it was fine. The calculations were fine. NTSB concluded that FIG's original design was defective. So it was not sturdy enough to hold its own weight. And then B, Lewis Berger should have caught these deficiencies. Yeah. Okay. So that's basically their biggest finding. So to answer your question, using the NTSB's opinions, it was a defective design. That's what caused it collapse. What caused a mass tort here was the fact that they still moved the bridge into position, knowing that there were cracks on the side of the road. Yeah. And then tried to do repairs over an open roadway with the public right of way underneath. Yeah. So what caused the collapse? Negligent design. What caused massive harm to numerous people? I mean, if it collapsed on the side of the road while they were doing tensioning work, it probably most likely would have harmed some of the workers, because you would have been doing the tensioning work, or if they closed the road, it still only would have involved the workers, because whenever you have a construction site, it's always the sign safety first, then keep out, right? So some workers might have been injured, and that's a tragic thing. But this kind of work is very dangerous. Yeah. But you don't subject the public to this, So those are the two reasons. Having the and it's rooted in common sense. But there's one concept of prosecution, civil prosecution too, which is called the rules of the road. And what are the rules of the road here? And the FDOT, the Design Standard 600, reflects that in Florida, the Florida Department of Transportation, that you shall not do work over an open roadway. Yeah. And that it just makes sense.
Common sense, yeah. That's crazy. All right, so I now want to shift over into the bankruptcy discussion, because Johnson & Johnson with the talcum powder cases, a lot of people are unnerved about how they use the bankruptcy process to essentially minimize their liability. And in your case, you ended up in bankruptcy. So you went from the court over here to federal bankruptcy court?
That's right.
All right. So how did that happen? Like, first, let's start off, like, who gets sued? Was it one company, the designer, the manufacturer, construction company? Who got sued?
So that's a good question. So when I file suit, especially in a wrongful death case, but in any case, you have to make sure that you've done your due diligence and you're certain that you can prove your case that somebody is responsible for the wrongful death of your client. I mean, it's a very heavy thing in our society. If you think about it as an officer of the court, to say this contractor and this engineer, they had a joint venture, MCM and FIG, had a joint venture to put this bridge into position, to build it and put it in position, and they caused the wrongful death of my client. I mean, that's a heavy thing.
That's heavy.
It's heavy.
That's heavy.
So when the NTSB, the night before I filed my complaint, said that they were doing the tensioning of an open roadway, I immediately sued the joint venture only.
Yeah.
And my approach is, sue those that are responsible, that have non-delegable duties, and then engage discovery and then figure out who else is involved. So what we did here is that's exactly what I did. But then through, just now we have so much information that we can get from the internet.
Yeah.
So we learned, because there was a public bid process, the other contractors involved. So we knew that if there was tensioning being done, then it must have been this entity. If they moved into position, it must have been Y entity, and so we knew which ones were involved. So we started, through the discovery process, adding defendants until it grew to 28.
Yeah.
Making it very complicated to settle when you have 20 plaintiffs versus one defendant. It's a release, and you're releasing one entity. But when you have 28 defendants, and let's say there's a silo of about 11 defendants that are, one is a subcontractor and another's a subcontractor and is a sub of that, you can't settle with one of the subcontractors all the way down the chain without settling. They want to releases everybody all the way up, because they want to be out of the case completely. So there were different silos here. There were product. We sued the manufacturers of some of the product. We didn't know if the product was defective at the time. We suspected there could have been. We had evidence that the concrete, early evidence that the concrete might not have been a proper mix. Maybe there was something wrong with the metal. At one point, one of the metal suppliers, right after the NTSB took some of the relevant parts, took the rest of these sample rods and destroyed them, got rid of them.
Wow. Yeah.
So there's a silo, there's a group of the product manufacturers that we sued and the subcontractors, but they all needed releases up the chain. And that made it very difficult to settle with them. So when we had our first mediation, it was impossible to settle piecemeal. It had to be global. And a global resolution for this case, it seemed at the time virtually impossible. But a year after the case was filed, about a year and a couple of days after the case was filed, MCM filed for Chapter 11 bankruptcy. And what happened then was they tendered their insurance policy for liability. But also what happens in bankruptcy, as you know, is all the creditors come in, and there are other secured creditors and other unsecured creditors, other subcontractors for other jobs, maybe a pending lawsuit for another matter here or there. Right?
Yeah. Unrelated.
Yeah. And then there's a class of unsecured creditors, which are the FIU Bridge collapse victims. So I immediately engaged the services of bankruptcy counsel, as David Rosendorf and Corey Lopez Castro. And what they did was they represented our unsecured class just to have a voice in the bankruptcy process. And so what happened was MCM put their insurance money into the bankruptcy process, along with their other assets, as is done with bankruptcy. But they basically said this $40 million is going to be earmarked for the bridge collapse. And there's property damage issues. It's a $12 million bridge.
Yeah.
And there's FIU's out of bridge. So they wanted some money. And so there's this pot of money. So what we then shifted gears, and through our bankruptcy counsel, and because even though it's still a big unified looking group of 20 plaintiffs lawyers, I also hired my own independent bankruptcy counsel, because there might be a conflict that arises later on during the damages or allocation process. So I hired Andrew Roy.
Okay.
Andrew Roy. And so what we devised was, and we came up with was, if other defendants were to resolve their case with the group of plaintiffs and put money into this bankruptcy process, into essentially a pot, and to create a fund, right? then you can't sue that defendant in state court. So in other words, the company that did the tensioning, the post-tensioning over the open roadway, that was a subcontractor of MCM. If they were to put money into the bankruptcy process, you cannot then sue them, outside, once you get a bar order, there's a channeling injunction. So
you can't sue them in state court.
You can't sue them in
for the
state
same
court or any court. It's barred. They put in their money, and if the bankruptcy process is approved and the settlement is approved for these unsecured creditors, then you can't sue them. So now we don't need those complicated releases.
Yeah.
It's going through the bankruptcy process. So what started happening was this swell of this inertia began. It's like a tsunami. It was a huge wave of, well, let's try and get all of these defendants settled.
Yeah.
So we as plaintiffs lawyers, and you said something earlier about, it sounds like the Champlain Towers, it sounds like it's a lot of money, but is it? There were 100 people, almost 100 people killed, and there were a lot more injured. What is the value of a life? I mean, that's the title of Ken Feinberg's book. He was the one that administered the fund for 9/11.
Yeah. One of the big mediators in the mass tort world.
Absolutely. And so, it's a difficult process. How much is enough? But as plaintiffs lawyers, and I can't say exactly how how we devised the process of how much money is enough, but we did have a process where we determined there was a certain goal that we wanted. And then we knew each defendant's insurance policies. We knew the towers of insurance that were applicable. And so we knew that if we got north of X, that we would all agree to put everyone into this process.
Yeah.
And so, so we met that goal, and we put almost $103 million into the bankruptcy process. The peer review engineer that was going to check the work of, or did check the work of FIG, and did so allegedly negligently, or at least according to the NTSB, chose not to be a part of the bankruptcy process, maybe because they didn't have a nexus, they weren't a subcontractor, maybe intentionally, but they settled cases after that individually.
Yeah.
But, I was at the Mass Torts Made Perfect seminar, as you were, a couple of weeks ago. And of course, I've got my finger on the pulse, and a lot of people are concerned about the bankruptcy process and how that affects us on these mass tort cases. And I can say, this has been going on for a while. I mean, with asbestos, there's been bankruptcy with that. And so there are times that it looks on its face patently unfair and unjust. I mean, I don't know enough about the Johnson & Johnson procedure now to say what they're doing is right or not. But I do know that there are times when, we shouldn't be worried about something like a bankruptcy process, because I know I can speak from experience, at least for the Bridge case. This was a very straightforward, almost elegant way to streamline the process without the need for all of these very convoluted releases that needed to be done to sort of channel everything through the bankruptcy process and get this finality. Because justice delayed is justice denied. I mean, if we didn't have this process and we had to settle with these defendants individually, and some of them were said, well, we don't want any, it's much easier for them just to kind of go into the process and say, we don't admit any fault, but we're going to put money in, and we're out.
Yeah.
So so the lesson learned there is I think the Plaintiffs' Counsel, not that it hurt us in any way, but we should have engaged bankruptcy counsel early on. Yeah. Because we knew that the size of MCM and the amount of insurance they had, it was likely that bankruptcy was in their future. Yeah. Same with FIG, and they engaged bankruptcy counsel right away. We knew that, so maybe we should have did that. We should have done that earlier. And that's something I would do, when I'm involved in another mass tort case. I would involve bankruptcy counsel to guide us from the
get-go. Yeah. All right. So I'm involved in the Boy Scouts matter, and that's in bankruptcy court. There's a proposed settlement. It might be getting approved by the judge. And I don't think it's really, I mean, from what I've seen, the terms look pretty good. I mean, I think that, is it perfect? Is it every penny everybody wants? I don't, obviously it's never going to be everything everybody wants, but I mean, that experience has not been horrific. I know in the opioid crisis with the Sackler family, I actually had one of the gentleman that was involved in the unsecured creditors. He was involved there, Ryan Hampton. He's come on my show. He was very upset, but he was upset primarily because the Sackler family was trying to basically get immunity from criminal problems afterwards or whatever. So, that whole, they were released from criminal liability, even though they weren't a named party to the bankruptcy proceedings. That didn't sound right or whatever. But I think, time will tell if this is going to be something that deprives a lot of people of their day in court or justice, allowing Fortune 500 companies to get off the hook, pennies on the dollar, whatever. Time will tell.
Right.
Two last things, I do want to, I know we talked about before we started this, that you wanted to conclude with the lessons learned. So you went over one of the lessons, which is hire the bankruptcy lawyer from the get-go. If you're involved, if you're one of these mass tort lawyers handling these large scale cases, you're all excited, you got good proof, you got good evidence, you got good damages, then you're like, oh my God, bankruptcy or whatever. Get the lawyer out of the gate so you can be guided from day one and you are paying attention to, the whole process, even before it unfolds. Before we get into the rest of your lessons learned, who was your client? What was the name of your client?
Ana Maria Oviedo Garcia was the wife. And
Okay.
Alexander Fraga was the son.
Okay.
He's an adult now, but he was a minor at the time.
All right. And what's going on with the bridge now? Is the bridge back up? Is it fixed? Is it?
Well, the bridge that collapsed, obviously,
It's
was
gone.
swept away. Yes, but they are going to build a new bridge. It's not going to be all concrete.
Yeah.
It's going to be a lighter bridge, primarily made of steel. So there's going to be a new pedestrian bridge up, and FIU had a ceremony honoring the victims recently this March, and it's a very nice thing for them to do.
Yeah.
I wanted to go back to bankruptcy for a moment and tell you that, one of the things that I also have comfort about are, at the end of the day, you've got the judges that are sitting approving these settlements. So I hope that if there is a situation where unsecured creditors are that were massively injured or killed in a mass tort MBL, that a judge won't just say, yes, I'll allow this affiliated company to come in and just pay out pennies on the dollar. I hope that judge, because they ultimately have the discretion to say, no, I'm not going to approve the settlement.
Yeah.
Just like in the bridge case, a judge, Christos Lagos was presiding, and he's the one that said that he wanted, in fact, there were some unsecured creditors that were contractors that objected, and they did so very respectfully. But they said, Judge, we're sort of pushing this forward and we want this done for the victims too, but we've got an issue. We're getting paid pennies on the dollar, and we're owed all this money, but the judge felt, but we have to do this to move this forward for victims. There can be a scenario where a judge, and I hope this will be the case, a judge will see past this, some defective product that harms a lot of people, and the judge says, no, I'm not going to approve this. I'm not going to allow this, So let's not, what I'm saying is, let's not hit the panic button yet.
Yeah.
Let's hope that the justice system will work to prevent companies from truly getting out from the responsibility that they owe when they harm people.
Yeah. All right. Well, I think that, I'm hopeful. I'm hopeful. All right. So we went through, I know you have a couple of other lessons learned that you want to touch base before we close the show. So let's go. Why don't you go through your list?
Oh, sure. Yeah. So because you're so diligent, we had a pre-interview meeting, and so one of the things that I shared with you, and I'm going to share with the audience, is that the media and how to handle the media in cases where there's a lot of great public interest, right? So people were killed. Is this going to happen to me? As Don Keenan would say, the reptile part of people's brains is lighting up, and they're thinking, can I get hurt with these construction cases and all of that? So when you file a complaint in state court, and you file the complaint, in a couple of days, it becomes live on the online docket. And once it becomes live on the online docket, which means you can access it, the media can access it, and then they immediately contact you. What I highly recommend, my media consultant is Cynthia Demos. What I recommend is before you file that suit, you connect with a media consultant, and what they could do is they can coordinate the press conference for you. Otherwise, you're going to be very reactive on what's happening. You're going to get multiple calls, there'll be multiple quotes, and it'll be very scattered. Instead, we had a very organized press conference about what happened. And also, this dovetails into something that is not quite in the ethical rules, but more of a moral thing. I think lawyers have to be very mindful of, what does your specific client, if you're representing one person, what do they want you to do with the media? Even if they don't talk about it, you have an obligation to basically know what they want. So there are some in our profession that will, maybe put someone in front of the camera just to put someone in front of the camera. I think that you have to know what your clients want. Some want privacy. Some want only the lawyers to speak. Some don't want any press conference, and you have to honor that. But this case had so much public, attention, and interfacing with the media, interfacing also with the lead news investigator was Tony Pipitone, who's great at what he does.
Yeah.
He was very frustrated that he couldn't get a lot of information because of the protective order, but he was diligently in all of these court special set hearings, and he was great at covering everything and doing it so respectfully. And I think it's important that, when there is a case like this, that the plaintiff's lawyers have this unified front, that yes, we are, pressuring the defense to give us text message records that prove that they knew there was something wrong. And we are battling in court,
Yeah.
but to do so in a respectful way so that the public can understand and appreciate and trust the justice system. If it looks like a circus, they're going to lose trust.
Yeah.
They're going to lose faith in the system. So the public media, it's important to look unified, to be dignified. And Judge Bailey was very cognizant of that. She was very aware of that that we want to move the case forward. We want to do it fast, expeditiously, and try and give as much information to the public as we can that NTSB allowed us to give. So that was another thing. The managing of the media is important when you're handling a case that involves mass torts. The other thing I talked about a little bit was the NTSB investigation, how important it is when you have any mass tort to work with federal investigators. A lot of government, I know that there's this perception, you mentioned it a little bit, that sometimes they favor the companies, but most of the time I've learned that, and I was a government employee as a prosecutor, they try and do the right thing. That's why they're there. And they're public servants. And they're not going to tell you things they're not supposed to tell you, but you can certainly work with them. And if you draw a Venn diagram, sometimes there's a mutual zone of interest for everybody. And so definitely work with federal investigators and meet with them, and don't pressure them and say, well, we demand to be a party, when in the federal rules you can't.
Yeah.
But you work with them, see what historically they've done in the past, so that you could say, well, just to give us the fair treatment that you gave someone else, can we also use this protective order that was used in another matter? And so that's another lesson learned. And then finally, we talked about the importance of preserving the ESI, or electronically stored information or evidence. In a case like this, when the NTSB is involved, they usually pick up and collect and store all of the very important, relevant physical evidence. So that process has been taken care of for you. And they're actually going to test it for you, sometimes destructive testing. But the electronically stored evidence, including the cell phone records, are so critical and so important, because it has changed everything. When I first started practicing 23 years ago to now, that the cell phone communications, it used to be when I was doing DuPont cases, product liability cases, we used to find these intra-office memorandum. And so to create an intra-office memorandum, there's a lot of thought behind it. You draft something, you might have someone proofread it. Text messages are real time.
Yeah.
And people are doing the right thing. They're saying, oh, I've noticed this problem. I noticed that problem. And they're there forever, right? And so social media, there was so much social media, so much promotion of these subcontractors. This is what we're very proud of doing. And then their marketing materials, for example, MCM, every accident can be prevented was on their website. All accidents can be prevented. Safety is our #1 priority. Things like that are going to be potentially used against the person. So #1, preservation of cell phone records, computers, all of that stuff. And also metadata on documents. We found some documents were changed. So the cover up sometimes is worse than the crime, right?
Yeah, exactly.
So that's another lesson learned. But every case is different, obviously, and unique. And I think the final takeaway is that there are some that feel or perceive that, this is a mass tort that's going on, or there's a big case going on, and there's one leader or two leaders or a steering committee, and they're doing everything. And that's not true. I mean, it truly takes a village. You
Yeah.
know, it takes a team, a very big team, a big network to lift this giant mountain and move it.
Yeah.
You can't do, you know, there is no one atlas. Sometimes marketing materials might reflect this atlas type person, but really it's the hundreds of lawyers even and the paralegals that are, you know, blood, sweat, and tears that they're putting into it. And then at the end of the day, not to lose sight of the actual individuals that we represent. You know, to not forget, you know, if you ever hear a story about, like on a documentary on Dateline or whatever, on a product defect like 3M, they're not just going to just talk about the product defect and what 3M did wrong in their design process. They're going to start with a story of a veteran who, you know, sacrificed, all of these things for his family to go into a war zone. And, you know, it's all
Protect
stories
us,
to protect us and to serve our country. And so you always have to remember that, you know, we represent individuals, you know, against these very big, powerful corporations. And so, again, it takes a team, a big network of people. And I'm proud that you're in that network and that we work together on some of these mass tort cases. And it's just a real pleasure and honor to talk to you today. And I hope that we have more discussions like this.
We will. So, you know, going back to the media, and I'm just going to end it on this, you know, a lot of times you have tough cases. What do you do with this? What are you going to do with that? The client's difficult. The judge is bad. The other side is difficult. And I always go, even going back to the media thing, I always say the answer to all these questions is what's in the client's best interest.
That's right.
And I remember early on in my career, I had a couple of, you know, interesting cases and the press was, you know, all excited about it. And I was like, any press is good press. And I just jumped right in there. And the first 2 times I got press in the Wall Street Journal, Miami Herald, St. Petersburg, it was bad. It was bad. And I, you know, circled back and then I said, I'm never again going to talk. But that, you know, there is a place for the media, you know, and as long as it is in line with your client's best interest, I say, you know, do it, you know, go for it or whatever. But in any event, it was a pleasure and an honor to meet with you over here today to discuss this in front of Miami Dade County Courthouse, the sick building. So listen, folks, I'm going to put Christos information, his bio link in the show notes. And this is going to be on YouTube. Very handsome guy. He's a little bit more handsome than me, but, you know, I've been beaten up a little bit more. You know, I think I got 4 years on you or whatever. So, and those are 4 long years. All right. I'm also going to put a little link about the, you know, all the infrastructure problems that we know about in the country. So, I mean, don't be surprised if more bridges collapse, more buildings collapse, and you need an attorney that can put it together, not some flash in the pan. And this is your guy, all right? All the other powerhouse attorneys in Miami knew it. They could smell it, they could sense it. And they selected Christos to run the show, and he did a fantastic job. And again, it's an honor and pleasure to have you on Cut to the Chase. Subscribe, rate, and review, questions, comments. You want to bring this guy on and talk another topic? Let me know, all right? And that'll do it for this episode of Cut to the Chase.